Hey guys, I think there was a turning point in the legal proceedings where the original claim was amended, and the amendment was very interesting. So I'm going to just read you as neutral as possible the amendment, add some takeaways. This is a very interesting discussion because of the amendments, and as the cases get stronger and stronger and stronger, I think initially Karl Jobst was overconfident, but then the amendments came and it kind of changed how the lawsuit was viewed. So this is the second further amended statement of claim. This is a claim in this proceeding is made in reliance on the following facts. The plaintiff is and was at relevant times a natural person. This stuff is all the same, right? In Western Florida, and well known in Queensland, Australia, or elsewhere as a competitive video gamer. So that's why the plaintiff would have standing here to sue the defendant. Particulars elsewhere includes the following: the rest of Australia, apart from Queensland, and all these other countries that are listed. This isn't the interesting part is how the claims have. I think Karl Jobst is being honest that to him it may have felt like a completely different lawsuit. Now it was the same lawsuit, and Billy Mitchell's son is correct. It's been the same lawsuit this entire time, been one singular lawsuit. But I could understand how somebody who, like Karl Jobst, would think that this is like piling on, or it was creating a different issue at hand. So here are all the list of all the other countries that Billy Mitchell is known in. The core concept of law is just because you have a really good case in the beginning does not mean that is the presented case. It is up to your lawyer to do a good job evolving the case. The cases do evolve as discovery, as new tactics are used. My takeaway from this is that Karl Jobst's lawyers were actually worse than I thought, and the fact they didn't involve. It's almost like a basketball plan, or a basketball coach, and they're killing your team, and you got to change your maybe it doesn't work, but maybe it does work. You need to evolve what you're doing in response to what the plaintiff is doing if you're the defense attorney. So let's go over this. Guinness World Record Limited has recognized the plaintiff as achieving the following video game records. The first gamer to do this, the highest score, the first gamer to score 1 million, the highest recorded score in Donkey Kong, the highest recorded score on the Donkey Kong arcade game. Defendant is and was at all relevant times. So if you're Karl Jobst and you're reading this list of achievements and the list of countries where Billy Mitchell is recognized in, this kind of does look like a little bit like he's defending that, oh, I'm not a cheater. Here are all my records, right, that are legitimate. The defendant is and was at all relevant times a natural person residing in Brisbane in the state of Queensland, and the publisher of the digital platform YouTube of videos he makes available for publication throughout Queensland and other states in the territories of Australia and worldwide. The publisher of the video entitled "The Biggest Con Man in Video Game," and the Twitter handle. Now, the Twitter handle is going to be very important later on, and they kind of go back to this. It wasn't just the video. When they were trying to prove intent, they went to look at the Twitter. On or about May 26, 2021, the defendants posted the video on YouTube. The video was downloaded or viewed and comprehended by at least 519,000 individuals across the world, and at least 21,311 individuals in Australia, including individuals in the state of Queensland. So, even kind of crazily, if no one viewed it in Queensland, there might be an argument that no damage was done in Queensland. The publication contained the following words. He also sued Apollo Legend for $1 million. I haven't spoken about this publicly, but the lawsuit ultimately ended with Apollo giving in and settling with Mitchell. He was forced to remove all his videos about Mitchell's cheating and paid him a large sum of money. This left him deeply in debt, which required him to find extra work. But with his ongoing health issues, there was all too much of a burden and ultimately took his own life. Not that Billy Mitchell cared. On or about June 3rd, 4th, 5th, the defendant posted an amended version of the video on YouTube in which he removed the following part of the words from the video. So I haven't spoken about this publicly, all the way to not that Billy Mitchell would have ever cared. In fact, when Billy Mitchell thought Apollo died earlier, he expressed joy at the thought. So he had made an edit. It was amended. Now, what happens later, right? On June 9th, defendant posted a further amendment version of YouTube video, replacing the version of the video posted on June 5th, 2021, in which he added back in the video the words he removed in the version of the video placed in paragraph 6 hereof, and so that the video also, again, contained the words. From 9 or 10 June 2021, the video downloaded or viewed are comprehended by 7,500 individuals, 248 individuals in Australia. Until August 24th, 2021, at least 125,000 individuals, and so on. The republication. The words as contained in the publication and the republication were of and concerning the plaintiff in an ordinary and natural meaning meant and were understood to mean that the plaintiff required Ben Smith to pay him a large amount of money to settle his defamation claim, which caused Ben Smith to go into considerable debt and take on extra work to survive. So we're just going to keep reading. A major contributing factor in Ben Smith's decision to take his own life was the plaintiff's requirement that he paid the plaintiff a large sum of money to settle the defamation claim. The plaintiff hounded Mr. Smith to death. The plaintiff was the main cause, or alternatively, a cause of Ben Smith taking his own life. The plaintiff's conduct was a contributing factor in Ben Smith taking his own life. The words and imputations pled in paragraph 8 hereof, the imputations were and are defamatory of the plaintiff. As of the date of filing statement of claim on September 13th, the video has received 7,874 public comments. At least 396 of these comments, particulars of which are set out in the further embellished particulars of the further Second Amendment claim, concern publication and republication, and from that it can be inferred that the commenters had viewed and comprehended the publication and republication. So here was a very interesting strategy, was you're going to use the comment section to determine what was meant. So what was the intent of what was being said can be determined by how people are reacting in the comment section. So Billy Pac-Man claimed he will sue me for saying Apollo legend paid him money. I removed that portion from my video, not because it is wrong, but because this isn't the issue I want to go to court with. I'd rather he sue me over his fake Donkey Kong scores. Again, he removed it not because it was wrong, but so there was no apology. There was no even admission that this thing was corrected. The hubris, or hubris is probably a good term. The arrogance of Karl Jobst is on full display, because I don't think at this point in time he thought he could lose. And the reason he didn't think he could lose was there wasn't presented a very clear argument as to what he actually did, which was presented in this amendment. This amendment is done incredibly well, and you can see from the date, it is very, very close to trial. So this amendment, January 23rd, 2024. The trial, I believe, was in October 2024. And this was a second further amendment statement of claim. This is a very fascinating case because I think Karl thought he could win, was pretty certain he would win, and that's why he was braggadocious. That's why he was on Camelot spilling the beans, right? Like, Karl at that point in time didn't realize how much serious trouble he was in because the serious trouble came later, or it was explained to him. Now, again, all these things he did, he already did, but when you're looking at people's comments, and that's probably something that him and his lawyers didn't look at or even considered what was relevant to the defamation case. Each of the imputations pled in paragraph 8 hereof is false because the settlement of the legal claim between plaintiff and Ben Smith did not require Mr. Smith to pay any money to resolve the claim, and the settlement did not contribute to Mr. Smith taking his own life. The plaintiff did not hound Mr. Smith. The plaintiff claims damage to vindicate his reputation. That's what it's always been about to Billy Mitchell. I don't think it's ever been about money to him. So for Karl to then make it about money after and during bankruptcy, I don't think it has any effect on Billy Mitchell. Compensate him for the stress and embarrassment he suffered as a result of the publication of the words as contained in the publication and republication, and the premise of matters pled in paragraph 12D herein to reflect the fact that defamation plaintiff occurred. The plaintiff claims aggravated damages and reliance upon the attenuated sense of hurt, grievance, and injury suffered by him, caused or occasioned by each of the matters referred to in paragraph 9, malice or unjustifiable or improper conduct of the plaintiff, plus the publication and republication were reckless indifference manifest by his failure to make any or proper republication inquiry as to the true position, the extravagant and sensationalization public content publication. Particular, such intent is inferred from on June 18th, 2020, the defendant posted the following comments on Twitter. Again, they're not just looking at YouTube anymore. They're looking at what Karl Jobst said after on Twitter. I restrained myself from talking about this, but I think it is now time for me to step up. F. Billy Mitchell, and does the fact that I am in Australia make it more difficult for Billy Mitchell to sue me? These are things that your lawyer will tell you you shouldn't be tweeting about. These are things that you do not want your client to go rogue and talk about this. So, in fact, this piece of document is probably why Billy Mitchell won, and definitely why Billy Mitchell won so much money. It came late in the trial. The litigation was a long time. I think it was 4 years. This came at the very end, right? Probably one of the last things. And the Karl Jobst's attorneys had to respond in essentially real time to these claims. From June 13th, 2021, maintaining the imputations were true, including in Twitter posts pled in paragraph 12 herein of. The June 4th, the plaintiff posted a video on YouTube denying that he drove Apollo Legend to blank by imposing financial stress on him in the settlement of Apollo Legends proceeding, the Mitchell video. So the timeline was very well fleshed out. I mean, it's a very logical timeline when you look at it like this. Karl was going to argue that this isn't actually how things happen, and there are delays and things that would be done, like the retraction video and so on, and even to the point that he supposedly put it in the Dark Souls video because it could get more views. So it depends on who you believe, and based on Karl's own Twitter, and they didn't take anything from Discord. Had they taken stuff from Discord, I think it would be more obvious what the intention would have been on Karl's side. Defendant inquired with Apollo Legend's brother as whether Apollo Legend had paid money to the plaintiffs to settle the Apollo Legend proceedings. On June 13th, Apollo Legend's brother advised the defendant that Apollo Legend did not pay money to the plaintiff to settle the Apollo Legend proceedings, published the publication and republication with the intention of increasing views of and subscribers to his YouTube channel. And I think they kind of went after it in a very, they said, hey, the reason Karl's doing all this isn't because he truly cares, it's because he wants to increase views and subscribers. Obtaining a pecuniary benefit from people viewing the publication and republication and his other videos on his YouTube channel, and obtaining a pecuniary benefit from the publication of and republication in the form of money paid for the advertisements played before, during and after the video, and for the promotion of products during the video. I assume both of these had sponsored ads. This was a clever move. It's almost like they saved their actual argument until the end. And by the time the end came, Karl's lawyers couldn't scramble. And this is why Karl, his lawyers seem so out of, I was like, how can you work on something in 4 years and not know the timeline and get confused about something very basic during your closing arguments? This sounds weird to me. But in hindsight, the timeline set out by Billy Mitchell's lawyers, I mean, unless you confront the timeline and you have things to add, it took this long, it's a very compelling timeline that previous to this document does not really exist. So the arguments were not fleshed out until early 2024. And by that time, due to probably time limits, maybe even money limits, Karl Jobst's lawyers couldn't really come up with a good defense. That's why their defense seemed so ill-prepared, because they were not prepared. And that's why even in closing the argument, where it has to be excellent, because, I mean, no one's going to trip over yourself, right? But that's what they did. It's fascinating. Without the second further amendment pleading was settled by Peter Sumners of counsel. Your defense must be attached to your notice of intention to defend. So this is a solicitor for the plaintiff. Sometimes it's one document and it changes the entire case. I believe this is the document that really did change the case in Billy Mitchell's favor. And like I said, it seemed like kind of randomly, even when I was covering it, it seemed like Karl Jobst had a really good case. Maybe he would lose for defamation, but he definitely wouldn't pay this amount of money. But then they talk about the comments, they talk about the tweets, they talk about malice, reckless disregard. Now it all seems very bad. So in the beginning, I don't think Karl knew what he was signing up for. Only until the very end should have been apparent that, oh shit, this is like real bad stuff that they're claiming I did. Including regarding specifically Apollo Legend and Apollo Legend taking his own life. Anyway, let me know what you guys think in the comments below. Bye, guys.